Bright Duty. Every student
Hello
matters.
children, now we are going to start with our chapter 16, the judiciary, the judicial system of our country, how it works, what are its powers and functions, who is the main authority behind it, who appoints judiciary, and the entire judicial structure of our country we are going to discuss under this chapter. So first of all, coming to discuss about judiciary. Judiciary means what? It is the most important organ of the government. In India, we have federal system of governance. What we have? Federal system of governance means that government have two sets, one at the center and other at the states. In our country, judiciary is an independent body. In the previous chapter also we have discussed about that. All three organs of the government, legislature, executive and judiciary. There also we have discussed about that, the independence of judiciary in our country. So in our country, judiciary is an independent body and it works as an umpire. Umpire, the same thing. How? The role played by umpire in the ground of the cricket. In the cricket ground, the final decision is given by the umpire. The same way, judiciary of our country gives the final decision and everyone, whether it is government or the citizens, they have to accept it. The judiciary administers justice, interprets laws, protects the natural rights of the citizens, which comes under the fundamental rights, and then looks into the union and state laws. Union means central. Union means here central. This is about the union and state laws through a hierarchy of courts. Hierarchy means that at the country level we have Supreme Court. Then in the states we have high courts as well as district courts, and the many more are there, which we will discuss in the later slide. So this is the structure of the Indian judiciary. Supreme Court is also known as the apex court of the country. It is situated in the capital city of the country, which is New Delhi. Then after that it comes high courts. Most of the states and the union territories, they have the high courts. Third one, it comes about the district courts. This is the hierarchical structure. At the top level, Supreme Court, followed by High Court, followed by District Court. Now, District Court is having two different parts. One is about the civil court, another is the criminal court. Under this, the civil court, court of civil judge, court of munsif. These all works under the district court, under the civil court. In the criminal court, court of the session judge, court of the chief judicial magistrate, first class magistrate and second class judicial magistrate. So this is the entire structure of judiciary of our country. Now coming to the detailed explanation of the Supreme Court. It is the apex court, highest court. What it is? It is also known as highest court of the country. What is the composition? Who are the members? Who constitutes this? Who are inside the Supreme Court? How it works? So now it comprises a Chief Justice and the 30 other judges at present. This is the present. Number of other judges, this may be different in different years, who are appointed by the President of India in consultation with the Chief Justice of India. Chief Justice along with the 30 other judges. This is the present strength of the Supreme Court right now, and all of them are appointed by the President of India with the consultation of the Chief Justice. Normally, the senior most judge of the Supreme Court is appointed as the Chief Justice of India. In normal cases, some of the exceptional examples are also there, which you may study in the higher classes. Then next it comes about that the qualification of judges. At present, a person to be appointed as a judge of the Supreme Court, he or she must be a citizen of India. Work as a judge of one or more high courts for a minimum period of 5 years. Then this is the 5 years. Minimum it is. Then an advocate in one or more high courts for at least 10 years. If simply he worked as and practiced as an advocate, then his experience, 10 years experience is required. Or a distinguished jurist in the opinion of the President of India. Who they have all these the qualities, all these qualifications can be appointed as a Chief Justice of India. Now comes about that the tenure and removal from the office. How long after the appointment as a Chief Justice of India, how long a Chief Justice stays in his office? How long he can work in his office? And the next, how he or she may remove. The Chief Justice may remove from the office. So these are the the two different things which we are coming to discuss. There is no fixed term of office for the Supreme Court judges. They remain in the office till the age of 65 years. They have the retirement age. They are getting retired at the age of 65. Then another most important, this is the tenure. What it comes? This comes under the tenure. Tenure means the period. How long Chief Justice can work in his office once he is appointed. So they do not have a fixed time period like the government for the 5 years. It is not like that. They are getting retired from the office. Once a judge is appointed, he cannot be removed from office under normal circumstances. Normally, once if they are appointed, they cannot be removed. Normal removal is not there. The process is a bit complicated. He can be removed only on grounds of proved misbehavior or incapacity to discharge the functions by the President on the basis of a resolution passed by each House of Parliament by a special majority. It's a very difficult process. Means that what the charges can be proved against that the removal of any of the judge? Misbehavior. If he has misbehaved, he or she has misbehaved. This is the number one. Incapacity. Means that if he or she is not capable to hold the post, to discharge his functions or the duties. In those cases, the President of India has the power to pass a resolution in both the houses of the parliament. Both the houses means in the Lok Sabha as well as in the Rajya Sabha. Lok Sabha and in the Rajya Sabha. By a special majority. So this process is called impeachment. Means that the removal of the judges by passing the resolution from the parliament on the recommendation of the President of India. And this entire process means the removal of the Chief Justice of India is known as impeachment. Then once they are appointed, getting the office of the Chief Justice, what are their salaries? Not only that Chief Justice, but the other judges also are there. Chief Justice of India receives 2,80,000 per month. This is the current data. Whereas the other judges get rupees 2,50,000 per month. Other than this also, they are provided many facilities such as official residence, travel allowances, leave, pension on their retirement. Other than this monthly salary, they are getting all these facilities. Next, it comes about that powers and functions of the Supreme Court. Under this, the powers and functions, first it comes about that original jurisdiction. It refers to the cases which directly have to come to the Supreme Court for hearing. Original jurisdictions means it has not been heard in any of the courts. And when it comes directly to the Supreme Court, then it is known as original jurisdiction. These cannot be taken to any court. Such cases include disputes. What type of the cases comes directly to the Supreme Court? So the disputes. What type of the disputes? Arising between the union and one or more states. Union means the central. This means the center or central. Between the union and a states versus one or more states, then it is known as comes under the original jurisdiction. Between two or more states, interstate disputes regarding sharing of water and power also come under this category. Kaveri water dispute is always there in Tamil Nadu and Karnataka, and it is getting solved by the interference of the Supreme Court. So these cases, these types of the cases comes under the original jurisdictions without presenting in any of the other courts. Directly it comes to the Supreme Court. Then it is known as original jurisdiction, original power of the Supreme Court. Next is appellate jurisdiction. This is about the appellate jurisdiction, means that appeals has been done earlier. It includes appeals against the judgments of high courts and other courts regarding constitutional, civil and criminal cases. Any type of the cases can be. If suppose the person who is not satisfied with the judgments of the high courts, any of the high court or any of the lower district courts, in that case they may represent to the Supreme Court. Then it is known as appellate jurisdiction. Means once appeal has been done, the Supreme Court has the authority to review all the decisions of the high courts. All the review, judicial review, this is also known as a term is been used, judicial review of all the decisions of the high courts. The Supreme Court can also review its own decisions taken earlier. Even though the Supreme Court also can review, if suppose that earlier they have taken or given any judgment or decision in any of the cases, those cases can also be reviewed, reconsidered by the Supreme Court, which is all such types of the cases comes under the appellate jurisdiction. Next, it is advisory jurisdiction. It covers constitutional issues. In advisory jurisdiction, it completely covers the constitutional issues or matters of public importance. If the President of India desires to obtain opinion of the Supreme Court, may give its advice or opinion, which may or may not be accepted by the President. So this is very interesting. What it says, covers, it has the power to cover the constitutional issues. Also covers that the matters of the public importance. If the President of India, if he or she desires to get the opinion, to take the opinion of the Supreme Court, advice is also given by the Supreme Court, but it depends upon that the President whether to accept or not. It is up to the president to accept the advice of such or make changes in it. Direct, those advice which is given by the Supreme Court can be accepted or not, or if suppose the president thinks that it can be accepted, then easily he or she can make changes the advice given by the Supreme Court. Court of record. This Supreme Court is also known as the Court of Records. All the records, all the cases brought to the Supreme Court, and where judgment has been given are maintained as record by the Supreme Court. Entire proceedings which are taking place in the Supreme Court is been recorded. So Supreme Court is also considered, also known as the Court of Record. The most important thing of the Supreme Court is the custodian of the Constitution. Custody means control, guardian. So it is the duty of the Supreme Court to uphold the sanctity of the Constitution. It can review a central or state law to establish its legality or otherwise. Whatever, the legislature makes the laws, executive executes the laws. But what a statement is also used in the previous chapter? Checks and balances. So this work is done by Supreme Court. It can review a central or state law. What they have, the central government has passed the law or the state government has passed the law. Whether it is the legal requirement is there or not, whether this the state government or the central government, they are not supposed to misuse their power. In that case, it has the power given to the Supreme Court to review this. If the Parliament passes any law that is against the Constitution, the Supreme Court declared that law as unconstitutional or null and void. Unconstitutional means it is against the Constitution. Such provisions are not made by the Constitution makers. So this is the power given to the judiciary through the Constitution. These powers as a custodian of the Constitution, there also the entire description is given how the Supreme Court can take decision. So whatever the laws made by the Parliament, made by the state legislatures, if Supreme Court finds any type of that, the mistake in that, these governments, they have not taken care of that, the constitutional provisions. In that case, Supreme Court has the power to declare that law as unconstitutional. Then it comes guardian of the fundamental rights. In the fundamental rights previous chapter, we have gone through about that. What it says that for that the violation of the fundamental rights, we can easily move to the court of law, which has been explained in very detail in the rights to the constitutional remedies. So according to this fundamental rights, the Supreme Court is considered as a guardian. Supreme Court of India is the guardian of the fundamental rights from being eroded. No one can erode it, abridged, or infringed upon by any person, group of persons, or the state itself. It can issue writs to the offending party or parties. If suppose that anyone files a case against that the government, against that the party, against that the any of the individual, then as a guardian, it is now the duty of the Supreme Court to take care of the citizens of the country. They can have to issue the writs against that party, against that government, against that individual person. So in that matter, it is known as it is considered as the guardian of the fundamental rights. Next, it comes about High Court. In the hierarchical order, first we have discussed Supreme Court, now coming to the High Court. So, what High Court says? The High Court is the highest judicial authority in the state. Supreme Court is for the entire country. Apex Court. This is the High Court, is the highest judicial authority, highest judicial system in the state. India has 21 states. Now we have at present 28 states and the 9 union territories. 9 union territories including Delhi as NCT. In each of this, the India provides for a High Court. This is the constitutional provisions. Every state they must have one High Court. But in our country, we have in some of the states common High Court system is also there for 2 or more states or union territories. Example is quoted over here about Punjab and Haryana as well as Chandigarh as a union territory. They have the common High Court facility. But Delhi as a NCT has a separate High Court. There are 25 High Courts in the country. 6 having control over more than one state or UTs. So 6 High Courts are there in our country which they have the control, like we have Andhra Pradesh and Telangana, but they do not have right now the separate High Courts. So they have only one High Court. So that way only these UTs and the many of the states they have a common High Courts. Coming to this, the composition of High Court. These High Court consist of a Chief Justice and some other judges appointed by the President. Again, the number of judges is fixed from time to time by the President. It depends upon that the needs and the requirement of the state, how many judges are required. So it depends. The number of judges, their number can be changed. So they are appointed by the President in consultation with the Chief Justice of India of the Supreme Court. Obviously, we have one Chief Justice only who is for the Supreme Court and the governor of the concerned state. Now, the role of governor is also important. Appointment power is given to the President, but before to appoint anyone as a Chief Justice of the High Courts, President must have to consult the Chief Justice of Supreme Court and the governor of the concerned state. Then only a Chief Justice for the High Court can be appointed. Qualification of High Court judges. What are the qualifications? Which is the requirement? How one can, any of the lawyer or any of the advocate can become the Chief Justice? A person to be appointed as a High Court judge has to fulfill the following qualification. Person must be a citizen of India, served as a judicial officer in the district court for 10 years, practiced as an advocate in a High Court at least 10 years. In a High Court as an advocate must have practiced for at least 10 years, and he should be a renowned teacher of good reputation in a law college. So this is the additional qualification. On that ground, on that basis also, he or she can be appointed as the Chief Justice of High Court. Coming to this, the tenure and the removal process. A judge of the High Court serve till the age of 62 years. Or as the Chief Justice of India, Chief Justice of the Supreme Court, 65 years. But for the High Court, it is 62 years only. The judges of the High Court can be removed from office by the President of India in the same manner as the judges of the Supreme Court. So what is the term used over there? How they can be removed? With the impeachment process. Means resolution passed by both the houses of the Parliament, then only it can be imposed. They can be removed. A retired High Court judge can practice in any High Court, any of the High Court. After getting his or her retirement at the age of 62 years, he or she can practice in any of the High Court, not in the same High Court. Not in the same means from where they are getting retired. Suppose that the Chief Justice of Delhi High Court, if he or she gets retired, they cannot practice in Delhi. They can practice in Punjab, Haryana. They can practice in Himachal, but not in the same state, not in the same High Court. Next, it comes about salary and allowance. At present, the Chief Justice of a High Court draws a monthly salary of 2,50,000 per month. Salary of other judges are rupees 2,25,000 per month. Besides this, they are entitled to certain privileges like a free residence, official car, and other allowances. Other than this, the cash amount as a salary, they are availing all these facilities which comes under their perks. Now, jurisdiction. How they can work, what are their area where they can give their judgment, where they can give their decision. Every High Court has been empowered to issue writ, orders, directions, etc. to any person or authority within its territory for the enforcement of the fundamental rights or for the other purposes. Fundamental rights. Now, again, you can understand about that, the importance of this right. For the fundamental rights, a person, if they can feel their fundamental rights are being violated, directly they can approach to the Supreme Court. That comes under the original jurisdiction. Even though, if suppose that the person, he or she can appeal to the High Courts also directly. So these are the original jurisdiction of the High Court. Then comes about the appellate jurisdiction. A High Court also has appellate jurisdiction. Means appellate jurisdiction means that anywhere it has been appealed in the district court, it has already been appealed. The person is not satisfied with the decision, then it has to be sent to the High Court. Then they can apply again, they can appeal again for the judgment in the higher court. So this is about that. The High Court also has appellate jurisdiction over civil and criminal. Civil means what? Related to our property, land. Then it is known as civil. This is about the land, property. Criminal, any type of the thing, like theft, robbery. This comes under the criminal cases. Murder, all such comes under the criminal cases. This is brought in appeal against the decisions of the district courts. Against the decision, once they have already applied in the district courts, district court has given their judgment, but these people are not satisfied with the judgment given by the district courts. So, with the help of those judgment given by the district court, they can appeal to the High Courts. This comes under the appellate jurisdiction of High Court. The High Court also performs certain administrative functions. It supervises and controls the working of subordinate courts. Subordinate courts which are in the districts, in the different districts of the states. This also frames rules and norms which from the guidelines of the lower courts. How the lower courts, the court of Munsif is there, first class magistrate court is there, second class magistrate court is there. Then a municipal court is also there when it comes to the civil cases. So this is all about that. So it comes under the rights and the appellate jurisdiction of the High Court. They can make the rules, they can make the laws, and they can give the guidance to the lower court.